All right. Well, welcome all to another episode of Chairmen of the Boards. And we have the great honor today of hosting two incredible attorneys, juris doctors, as they might be known in some circles. And they are going to be walking us through some of the new developments that have occurred in the lawsuit between Klon and Behringer. And I know we've talked in previous podcasts about some of the details of the case from non-technical, non-attorney people that are just industry folks. But there have been some significant changes subsequently, namely that Behringer has changed the look and name of the product, and that there has been an additional, Lauren, you might be able to correct me on this, an addendum or some sort of change to the complaint. What's the proper language from an attorney's perspective?
It's called an amended complaint, and so in this world, it's essentially taking the place of the original. So it is the operative or the live pleading is what we would call it. So it's
still a lawsuit at this point.
There is still a lawsuit, yes.
All right. So this is interesting. So I guess I should introduce, this is the perfect time, the two incredible attorneys that have donated their time, and as you'll see very extensively, to do some research here. Lauren Aldredge, did I say that correctly?
You did.
All right. And Brian Pounds. And Brian organized all this. So today there's going to be multiple Brians, and you'll just have to use your deduction skills to figure out which one we're mentioning at the time that we say it. But maybe, Lauren, for our listeners, if you could maybe rehash for us sort of the original case, and then we can sort of kind of go through the timeline of the changes that Behringer made, and then kind of get to the new suit and or the new claim, I guess. And maybe we'll all interject some questions, and I'm sure Brian Omilion will also interject some questions in the meantime. But if you could just sort of catch us up on some of the broad strokes of the original case, and we've got screen sharing enabled, so you can share any of the documents that you've created to help us kind of best understand what's going on here.
Sure. The way that lawsuits work, generally speaking, is you file a complaint, and that if you were the filer, you're the plaintiff, which is what Klon is here. In that complaint, you are supposed to set out they call it a fair notice standard, enough information for the person that you're suing to understand why you're suing them. So here we have the original complaint, which was filed back late May, and it's a claim essentially for trademark infringement. And I watched your prior podcast, and I've read all the Reddit subs and all of the things that are going on about this, because I want to be very upfront. I am not a pedal head. I don't know a whole lot about this world.
But you're making a good case that you could represent one. You're making a great case already.
I'm learning a lot, and I'm loving it.
Before you get too far into it, this is my favorite part of this whole prep thing. Because I also watched the previous podcast, and I've done some trademark work. I used to work for Lauren, and now I'm at a different firm, not doing trademark work. But I know a little bit. I'm kind of just weaseled my way into not knowing enough about pedals and not knowing enough about trademark that I can still put my face on camera. But I'm hoping to act as kind of a translator, which I think is best personified by as we were prepping for this. We're going through the standard. One of the things is like the sophistication of the user, right? Which we'll get to. But Lauren goes at one point, she goes, like it's an interesting product or whatever. And there's a lot of small changes and everything. But like, who's ever going to know or look at what's on John Mayer's Pedalboard? So that my job is to just act as a compressor. Just to
these are the tone perverts are replete in our industry.
Yeah. The fan pages on fan pages that are literally dissecting.
That was early on, and now she's
I get it now.
Coming up the expert.
Well, I was like, from a fan, I was like, I'm watching the person on stage. I'm not necessarily checking out the pedal boards, but now I understand how important they are.
Okay.
So and this original complaint, and what you guys talked about in the first podcast, you get the gist. Like you guys understand, it's a complaint for trademark infringement. They're saying Klon is like, we have this pedal. they've made a copy of it, and they didn't even bother, like some of the other ones, to change the name or really even change any of the protectable elements. And so they're mad about it, and they filed a claim for trademark infringement. It's pretty straightforward, and we can get into like the strengths of the case and what is likely to happen. I do want to kind of draw a distinction between in the legal field, liability and then damages. So liability is kind of like, did you do it? And that's one question a jury would have to determine in any lawsuit. And then the second question, which I think you guys spent a lot of time on trying to tease out, is the damages portion. So if you think about it like speeding, right? Okay, the speed limit's 35 miles per hour. If you're going 36, you are liable. You did it. You're speeding, right? But what are your damages? Are you going to get fined? Was anyone harmed? You know, what's the delta between what you did and what was wrong? You know, so if you crashed your car into a building and caused millions of dollars of property damage, then yeah, there might be some damages related to that 1 mile per hour speeding. But I think in order to kind of answer the question as to what's going on here, is Behringer liable for trademark infringement? That's one question. And then if the answer to that is yes, then it's like, well, okay, what does that cost? How much are they on the hook for because they're liable? And those are two separate questions that have different analyses, and sometimes they're even addressed in separate trials or separate phases of a trial. So I think that the original lawsuit was pretty simple, one claim. You know, we make this pedal, you're making a copy, and we were damaged because of it. Then Behringer went and changed the pedal, changed the name, and Klon was like, see, that's proof that they knew that what they were doing was wrong. So now we've got willful infringement. It doesn't fix the past infringement in the eyes of the law or the eyes of Klon. And now you didn't change it enough, so you're continuing to infringe with a new pedal and a new name that's not quite far enough away. If they had gone with Mermaid or Zeus or Tumnus, right, who is a centaur in the Chronicles of Narnia, that may have been far enough away. But they didn't. They changed a letter, right? And so I think Klon's argument here is they did it, they bragged about it, they weren't ashamed of it, and the change was sort of insulting. So now we're going to add some claims here.
There's just one or two things I just wanted to add from a broad legal perspective. One is sort of, I know you were talking about motivation for why this might have occurred. And then to add on to the damages point, generally across the law, damages are really supposed to put you sort of back into the position that you would have been, right? So if you stole a $500, I'm looking at a screwdriver. If you stole a $500 screwdriver from me and I had to spend $25 in gas to go to your house to pick it back up, really the law says that somewhere around $525 is what you owe me, right? It's different. I know that people see giant billboards and car crashes and things like that, where there's millions and millions of dollars of damages, but those aren't tied to just a jury picking a number out of thin air. It's oftentimes tied to like, what's it going to cost to have care for the rest of your life, kind of thing. You know, those kind of things. It's tied to actual damage. It's just not picking out a number. What's interesting about trademark stuff, though, and Lauren, you can correct me at any time if I'm off the rails on intellectual property stuff, but there's statutory damages, which means that you get damages sort of automatically if you prove that there are damages. There's not, you know, if you stole a pencil from me and I got it back a day later and then I just wanted to sue you to be a jerk, I'm not really damaged because I got the pencil back and I didn't lose anything from it. But here, it's interesting what the potential motivations for the lawsuit might be, because it's really kind of a saucy complaint. Like, some complaints, there's an art to writing complaints. There, you want to have a little bit of fire throwing. You want to use some sort of incendiary language, but most of the time it's the judge reading it. So like you're not getting a whole lot from just being all over. And there's things like it's a brazen clone, and my favorite one was plaintiff centaur pedals have achieved a mythical and legendary status. Impeccable craftsmanship and quality, and utterly glorious tone. I was just really happy to read that in a legal document.
Well, they want the judge to know that that's what they're dealing with.
I do think it's relevant here just to know kind of the background of what a Klon is and how big of a deal it is. But I also think just with some of the language in there, I think it tends to show some of the motivation for bringing this.
Mm-hmm.
I wonder though if the attorney, like if Bill Finnegan is sitting there and he's like, no, that won't do. This needs to be glory. And the attorney's like, all right, fine, Bill. Like they belabored over that vocabulary, of exactly how they're going to word it.
And in the federal lawsuit context, Behringer, if they're going to answer the lawsuit, which is the next step here, right? They've been served. Their answer is due in 15 days at the end of July. They have to go paragraph by paragraph and either admit or deny the facts in each paragraph. So they're going to be forced to admit or deny that a Klon pedal has utterly glorious tone in writing.
Well, they kind of indicate that in their launch video, and that was sort of the impetus for why they made the pedal at all. That it was sort of on the Mount Rushmore of tone as far as guitar pedals are concerned.
Mm-hmm.
Those paragraphs you can also admit in part, deny in part, and I'm really hoping I see like a deny or admit to the extent that Klon has utterly glorious tone, but deny as to the remaining paragraph. That would be
I'm curious about it in like the terms of like you were talking about damages and stuff, like how many, like I mean I don't obviously know any of this, but like Klon, as we in the last podcast we looked up, what do they sell, like 2? They do 2 of those boxes a month, those big
or
ones,
less, or some months none at all. Yeah,
like between $4,000 to $6,000. I get it. So like, if you're only selling them twice a month, like let's be honest, I have no desire to go buy a $6,000 Klon. I have a desire to go buy a $6,000 car, or put $6,000 towards a credit card bill or something.
For $6,000 anymore.
I mean,
buy a 2000 Hyundai Elantra.
Hey, I had a 98 Ford Ranger, and my kid's like, that's old. I'm like, no, that car was amazing. But it's like that. It's like it's going to be interesting, at least from my perspective. I understand their point. I think it's a little silly that if they're going to try to go after damages, because the amount of friends that I know that are like, I literally would have never spent $6,000 to $8,000 on the Klon, but I'll go buy $100 Klon. And what's this one, when you brought up the Tumnus name earlier, another company has a Klon type pedal called the Tumnus.
Whoa.
So like it's from J Rocket.
It's an obvious place to go.
Yeah. So like it makes sense. Like there's so many, it's just interesting because it's like people like, because now so many of these pedals have been bought and they have the original name and stuff, and people are like, ooh, I have the pre-lawsuit Klon, Behringer Klon, I have the post-lawsuit Behringer Klon. So it's just one of those things. I don't know if it's my brain going kind of like, I get your point, but it kind of feels petty because like if they would have ripped off they did a newer version called the KTR.
Klon created a pedal called KTR.
KTR, Klon, the reissue. It literally, like, he has wording on the pedal all about it. And he's actively making, I mean, I have a store here locally that they get like 25 of them a month. So like they're actively selling them. Mm-hmm. They're not selling 1 or 2 of them. But so it's just interesting. It's like, it's like you used to do it, but now you only do it when you feel like it. So yeah, it'll be.
Does that matter though, Lauren? Like from the perspective of if Klon, the version of the Klon that Behringer is replicating, at least partially aesthetically, there is sort of a a scale difference because the Behringer one is shrunk down to maybe 50% of the size.
Mhm.
Does it matter if, from a legal perspective, if Klon is only selling one a month or two a month? Like, is that, because we talked about in the last podcast that there's some element of like, is it actively being sold, or is there like commerce, around this product? Is that a factor in the lawsuit at all, or is that amount, as low as it is, enough to say, well, we're in the business of making this pedal, and by having this competition, there are damages that are being incurred because people are either buying this due to confusion in the marketplace, or they're buying this because there's an alternative that's undermining our product? Like, is that hold water, that amount, as far as proving that it's actually being used?
That's a great question that I think illustrates the liability versus damages question. It matters for damages. It doesn't really matter for liability. It's kind of a binary thing. Are
Okay.
so is he using it? Yes or no? If the answer is yes, and by using it, I mean the trademark. And Klon's trademark portfolio is, he has two trademarks for the word Centaur, one for like pedals and accessories, and then one for like service and maintenance of pedals. So those word marks for Centaur cover the use of that word mark in any application, and it's not the logo. He does not have a trademark on the horsey, as you were calling it. It's just the word mark.
That's this one here. Is this the
Yes.
Okay.
So that's going to cover, when you're looking at trademark infringement, you're looking at what is the mark, which is Centaur, and then what is the goods and or services, which for this one, it's electronic effects pedals.
Okay.
So then you've got a Venn diagram kind of that you're looking at to compare a potentially infringing product. How close are they to the name, the mark that's protected, and how close are they to the goods and services? So for the original Behringer, or the lawsuit Behringer pedal, right? You've got Centaur on there, and it's a guitar pedal. It's a pretty much a perfect circle on the Venn diagram, right? So that's going to be, if you're just looking at it, and again, Behringer hasn't answered the lawsuit, so I have not seen. I don't know what they're going to say in response, but that's a pretty close thing on liability, right? It's the same, basically the exact same name for the exact same product, and he's got a registration. Trademark rights confer based on use. You can't get a trademark on something that you are not using. You can apply for one if you intend to use it in the future, but you're not going to get the registration or the ability to sue on it unless and until you're using it. So, and use is a pretty low bar. It's just interstate commerce. So it can be a website that's up there. It can be once a month. It can be, $1 million a month. And I think in the amended complaint, he said he made sales in February, March, and April of this year. So he is using it. And if you on those trademark registrations, they are renewed every 5 years. So you have to demonstrate use every 5 years. He just renewed one of them, and the second one's renewal is coming up in September. So he's renewing them. He's demonstrating use. So it doesn't matter that it's not a lot of use. It's not really. It's just a binary thing, yes or no. And for damages, and kind of to Brian O's question, is there's two types of damages that are available in a suit like this. There's actual damages, which is what's going to be to put you back, where you were before the infringement occurred. And then there's statutory, or what some people call punitive damages, which is like, you did something wrong and you knew you were doing something wrong, so we're going to punish you above and beyond what you actually cost the person. The one thing that's interesting about trademark infringement damages is that disgorgement of profits is part of it. So if Klon is able to prove infringement, then they can disgorge all of the profits that Behringer has made on the Behringer pedals. And so that's where it kind of, it's not just Klon's lost profits for the 2 or 3 pedals they may have sold to a consumer who got confused. It's every single pedal that Behringer has sold. And you had some talks about the profitability of these pedals, but if they're making 20, $30 off of these pedals, and they're selling hundreds, maybe thousands of them.
Oh, I'm sure that when Behringer makes pedals, they don't make a few, they make tens. I would predict that there's at least 10,000 of them out there.
And it's all been back ordered too.
Right. Yeah, and I've seen the secondary market for some of these lawsuit pedals are getting up there closer to what the Klon pedals are actually being sold for. So that's a pretty hefty stick, to enforce these trademark rights, is the disgorgement of profits. And it's not just a recouping of Klon's profits, it's a taking of Behringer's.
Do you think that if you were advising, we'll get it from both perspectives, but if you were advising, let's just quickly table the kind of amendment to the suit that we now are aware of. At the point with which the original lawsuit was generated or was beginning to be drafted, if you were working with Bill Finnegan and in Klon, would this have been the approach that you would have taken, or would there be any change to kind of how you would have decided to go after Behringer, given kind of the Venn diagram sort of analogy that you used?
Yeah, it's interesting because the lawsuits are a good way to separate people from their money. And so personally motivated lawsuits are generally never a good idea because they seem like a good idea at one point. But, I've had clients who are like, I want to file this on Christmas Day. And I'm like, trust me, you do not want to do that. Like, that's just going to piss everyone off. But we don't know because it's not in the complaint. Typically, if I have a valid complaint for trademark infringement, if I'm representing someone who's going to be enforcing their rights, I send a demand letter to the infringing party, a cease and desist that says, and depending on the level of infringement and how the client feels about it, it can be an oopsie doopsie. Looks like you may have just started a competing business that's the same as my client. Please stop, and we won't do anything else. To you dirty rascal, screw you and your mom. Like, how dare you? If you don't stop, I'm going to take your house. But usually a demand letter or a cease and desist letter that sets out your legal position and your evidence and lets the opposing party and ultimately, hopefully, their lawyer know, what's going on, that this is a problem and that you're going to enforce your rights. I would say I have about an 85% success rate with my cease and desist letters at getting the other side to see my way, because I don't want to send them, certainly if I'm not going to be, confident in my position. But every now and then you get someone who tells you to go jump in a lake. I'm not stopping. You can't make me. Your mark is not valid or not strong. So I don't know if that happened here. I don't know if Bill Finnegan sent a cease and desist or a demand to Behringer, or was just like, you're a big giant company, I have no interest in negotiating with you. But in the amended complaint, and I don't recall if it's in the original, he talks about how he regularly polices the use of his mark on these other third-party clones, and sends takedown notices and works with them to kind of knock it off if it crosses the line from homage to copying. I know you had talked about that in some of the other podcasts about why aren't you doing anything else about these 30, the warm audio one or the Ceriatone one? And the answer is we don't know. He might be, or he may not think that it's a problem, but the duty is on him to police his mark, which is what he's doing. So if I was advising him, I would have said send a demand letter, but there may be a history of that or knowledge I don't have that would make that recommended course of action just not feasible. One thing that can happen when you send a cease and desist letter, when you're saying, hey, I've got a trademark or a patent and I want to enforce it, stop using it, stop infringing, is enough of a threat that the other side is like, I'm about to get sued. And so now there's what they call an actionable claim or controversy. And so the person who gets the letter can run and file their own lawsuit. And what it is that they can file an offensive lawsuit that says, I'm not infringing. It's called a declaratory judgment action. So if you get a cease and desist letter, you can say, hey, this is enough of a threat that I'm about to get sued, that I can go file my own lawsuit, where now I'm the plaintiff, I'm in control, I get to pick what venue I'm in, I might even get to pick my judge. And now, it's on me, and I get to go ask the court to say, before they've gotten a chance to put forth any evidence or anything, I get to go ask the court to say, I'm not infringing, and this guy doesn't know what he's talking about, case dismissed. And so that's the risk of sending a cease and desist lawsuit. Most people don't do that. That's a very aggressive move. But maybe they thought that was a risk here, especially given Behringer's size. And they probably didn't want to be the defendant that Behringer was suing, because then Behringer's in control.
Yeah. And Behringer, just as an aside, and you may have seen this in your research, they sort of have a history of doing these sorts of things, albeit it's generally in companies that are kind of either, for the most part, dissolved or not really in existence in the industry. But it wouldn't be the first time that they sort of just steamrolled and did this sort of things with other brands, because it's kind of been their MO, is that they recreate kind of legacy products and do it at a very, very inexpensive price and kind of inundate the market with it. And for people looking for budget versions of sort of classic effects, they kind of have an answer to almost everything in the industry.
Yeah,
I think that gets into like motivation for the lawsuit, like you were talking about, and a couple of legal principles that are kind of universally applicable is that, like 95, I don't know what the actual number is, it may even be up to like 98, but like 95% of lawsuits settle. Because like sitting here now, Behringer hasn't even answered, and Lauren has a pretty good idea about how things are going to go. Like there's not a whole bunch of surprises in the law the farther you get down the road. Like the facts are sort of gone over multiple times before it ever gets to a jury. The reason that something would go to trial is if people are being unreasonable, if you get pissed off, and it can get to be about what your motivation's about. And in looking at this complaint, the thing that stuck out to me was when they were referencing other clone pedals is kind of indicative of my guess of what one of the motivations might be, which is like, when it is a boutique manufacturer, when it's somebody doing a good job, they're not really hurting Klon all that much. Like Klon's, like you said, making 2 of the pedals a month or something like that. He's making the KTR, but he's a one-man shop. And by this time, if he wanted to, he could have exploited it and cut corners and made a lot more money than he has, probably, right? So he has some, principles that revolve around that. What he kind of continues to show up in the complaint that makes it saucy is that he's like, this thing's a hunk of junk, is sort of the vibe of it all, right? So if something sounds good and it's $300 and somebody can get 80% of a way to a Klon, and you're going to use it at your club gig or whatever, that's I'm not Bill Finnegan, but I would have no problem with that. And in fact, I would be somewhere on the scale of like okay with it to honored to helpful, to make sure that everybody kind of had opportunities to make this going. But when Behringer, and I don't want to say anything about Behringer because I'm not a good enough guitar player or pedal manufacturer, builder, whatever, to know. But assuming that Behringer's just putting out a really crappy version of the pedal, which is what they allege a bunch, it also kind of hurts the clone market. Because when you get somebody that is coming up and doesn't know the pedal super well, or is just maybe getting into pedalboard to start, right?
Their
Like,
first impression is colored by an improper replica.
right, exactly, because this one looks like it, which is also very interesting to me is what is actually protected. What's actually protected is the word centaur. That's what his mark is. Centaur.
Federally protected.
Federally, thank you. Yeah.
Does that matter though, even though Behringer is not based in America?
Yeah.
Yeah, you still get jurisdiction.
No, it does not matter. So it wouldn't matter if Behringer was manufacturing, if Behringer was copying this entirely in like China or Saudi Arabia.
And I think that they are.
Yeah, and selling it there and only there. Unless and you can get trademarks in other countries. So unless Klon had a trademark presence in the country where the infringement was happening, he wouldn't have a whole lot he could do about it in the United States. But the minute you sell here, right, the infringement occurs here, you're on the hook.
But is he only on the hook for what was sold in America, or is he or is Behringer on the hook for what's sold worldwide?
Well, that's a good question. And it's kind of, the website is based out of, the Emirates, and like all the sales are there, but they're being shipped to the United States. Websites can be accessible from anywhere. So it may be he's going to have a hard time drawing the line on his damages as to which damages are the United States versus which damages are extraterritorial. But so it does matter. The infringement does have to be here. I've seen cases where like someone hires, outsources work in India, right? And the person in India is either copyright infringement or, copying a bunch of stuff. But if the infringement's happening in another country, it can be difficult to enforce here if you don't have protection in those countries where the infringement is happening. But the minute a sale is made here, I mean, all of their advertising seems dedicated to at least an English-speaking audience.
Sure.
So, if I'm on the jury, I'm like, yeah, like you're trying to sell these things in the United States. I don't know which country has the largest guitar pedal market consumer base, but it probably us, right? I mean, I don't know how many guitar pedal users are in China.
Yeah, we're certainly the biggest, and then probably followed by Western Europe and Canada and Australia, and Japan has a pretty substantive fan group of fans, but it's just so much smaller in comparison in terms of number of people.
You just have more people.
What if you were to reverse and you were now taking sort of the position of being the legal counsel for Behringer? How would you have advised them to sort of deal with this lawsuit? And then maybe we can get into how they've dealt with it so far and why that may or may not have been a judgment error in your estimation.
Mm-hmm. Yeah, if I was Behringer's counsel, I would have been like, "Why did you do that?" No, I think the defenses that I would use are kind of a trademark dilution. And this is what you were talking about a little bit earlier with what Pounds was talking about was tarnishment, right? Trademark tarnishment, or these are reputational goodwill type damages, which can be difficult to define, but a jury is certainly able to put a number there. But trademark dilution is like a weakness or a blurring, where if you don't police your mark and there's 100 different similar products out there and you haven't said word one about them, then the value and the strength of your mark is watered down. And given just from what I've seen on preparing for this, it seems like there's a lot of clones and out there that are paying homage, but certainly towing a line that is more similar to the revamped Behringer pedal than the one that was in the original complaint. But that would be kind of my claim is like, you knew about this with these other 500 people and haven't said anything about it. Another thing is there's a like a doctrine of latches or a waiver argument, right? Like Behringer's been doing this for a while. Like, did he file a lawsuit the day after this pedal was reduced? Maybe, I don't know. But if he sat on it and didn't do anything, let Behringer copy other stuff, that might also be something that you could use as a defense. And I think also to what we're talking about, like what's protectable, Centaur is the only thing that's federally protected. There is a concept called trade dress, which is the look and feel. You can actually get a federal registration on that. Like Verizon, the red and black stores, the Genius Bar, Apple, the look of a Tide bottle, right? The red bottle with the target on it. That's those are examples of trade dress that have been federally registered and are protectable. Everything other than the Centaur word is kind of like what's called like a common law. Like there's no registration. It's just a smell test. Like, this has been out there for a while. I've profited from it. It's my business. It's my name. But I didn't actually take the steps to protect it. And so if I'm Behringer, I'm like, you can't protect a square box with knobs on it. Like that's just something that everyone that's what a guitar pedal does. That's what it looks like. And you don't protect the color gold. Where it's hard is that they use the word centaur.
Mm-hmm.
I mean, so my advice to them would be like, change the name to something very different. And then if you were interested in working with them, like to like your licensing agreement or some sort of like, oops, mea culpa.
Yeah. That just seems like the
get
obvious, like
off.
money,
Yeah.
like if money were the motivation. I know that Brian Pounds said, well, he doesn't seem that motivated by money because he had presumably multiple opportunities to cash in if he is able to command so much money for the one or two times that he sells his pedal every year. For most pedal companies, I would think it'd be like, hey, if I can make like 15% on every pedal and this guy's selling tens of thousands of pedals every year, that would be like the obvious, like, hey, this is, I would think that divorcing sort of the two different companies here, just taking this to like a generalized suit about copyright, that would seem like a great, an everybody win sort of situation. But yeah, it's interesting that they're not doing that. So do you think though that there is, it does seem so odd to me from a consumer standpoint, if I'm talking about market confusion specifically, the other pedals, like we mentioned, the Warm Audio, the Ceriatone, Centura, like these are using a casting that is identical to the Centaur and colorways that are the same as the Centaur as well. Behringer obviously is using a color that's a similar color as well with the gold, but the Ceriatone, for example, and I think also the Warm Audio, I think you can get it in the silver color. I think you can get it in the gold color.
Yeah.
And they don't say Centaur on it, so they're off the hook on that point. They do have some version of a Centaur graphic on it. It just seems odd, like from a market confusion standpoint, if I'm a customer and I'm seeing one of those, that to me looks more like I would accidentally grab the generic Cheerio box than like the actual Cheerio box or thing, because it's yellow and it's got the same shape and all this sort of stuff. Whereas when I see the Behringer one, it being so scaled down in size and kind of having a little bit different or a miniature version of it, to me, it's already a disqualifier on that as a consumer. It's curious to me that this has never been something that Bill Finnegan has gone after. And it's interesting to comment, like, is that a consequence of at least they copied the circuit properly and it sounds somewhat passable? Is that why it gets a pass from Bill Finnegan? Because certainly on all the other metrics, it pretty much is, you could take a circuit board out of a Klon and drop it in any one of those and it would fit,
Well, I guarantee you they'll ask him that, and if he's deposed as part of this lawsuit, why? But that goes into the factors of likelihood of confusion, which we can talk about because there's a fair number of them, but that's one of them.
Price is another confusion too. Like, would somebody really say, "Well, it's only $79 instead of $5,000"? It must be the same thing, I don't know.
I think it's interesting though that like the $5,000 clones, not the KTRs, it's not just one. Like a Coke bottle is always the same Coke bottle. It's changed throughout the years for sure, but like he has a silver one, he has one that didn't have the Centaur on it.
Yeah.
So if you see a smaller pedal and you think like I could really see a likelihood of confusion, because if I were Bill Finnegan, at some point I would think, oh, well, pedalboard manufacturing and pedalboard building has blown up in the past 20 years, and smaller footprints is a good idea, and if he had been able to make something like that and make it fit on your board, and it was more, it took up less real estate, that's not a bad idea that Behringer had to do, kind of thing. And so it's not out of the realm if he's going to make a silver one, if he's going to make a gold one, if he's going to make one with a centaur, why wouldn't he make a smaller one, kind of thing?
I think his argument would be, well, I made the KTR, and that was sort of the
right.
more pedalboard palatable one. I want to continue the dialogue, but before we do, I want to break momentarily to talk about a few sponsors that make this podcast possible every single week. I'm going to turn it over to Brian Omilion. Take it away, Brian.
All right. Yeah. So first of all, our three sponsors will be the guys over at the Guitar Sanctuary in McKinney, Texas. They have all sorts of Klons that we are talking about. They have the Archer, the Tumnus. They have all sorts of different pedals, as well as guitars, electric, acoustic, bass, ukuleles, amps, all sorts of stuff. So go check them out at guitarsanctuary.com. Visit them online in the store in McKinney, or shoot them a text message, give them a call. They would love to talk to you. Next are going to be our guys over at Neural DSP with the Quad Cortex and the Nano Cortex. If you have a Nano Cortex, they've done some recent updates allowing you some more effects blocks, which are super cool. I just literally built a little acoustic board for someone. Was able to take a capture of a Neve preamp that they had done, and it sounds fantastic. Put some reverb delay on it, and it was good to go, and it was all he needed. So go check out Neural DSP. Use the code Chairmen for 30% off all of their plugins. If you utilize plugins for recording or anything like I do for all my tutorials, it comes in handy when you need something really quick and you don't want to have to set everything up. As well as check out the Quad Cortex. It's the big brother to the Nano, has obviously more power to it, but they're both amazing. Check them out, neuraldsp.com. Use the code Chairmen, CHAIRMEN. Save 30% off of the plugins. Final are going to be the guys over at BTPA, or best known as Bestronics. Brad is our go-to guy for all sorts of connectors and cables. 2.1 millimeter audio power plugs. We have SP400 square plugs, as well as all of the bulk cable and TextFlex and everything that you need to build your board, as well as custom looms and wireless equipment. Use the code DACHAIRS, DACHAIRS, to save 10% off your order, which nowadays saving that money would be great. So saves a little bit of money, get some gear, build your board today. BTPA.com. I will throw it back to you, Mason.
Thanks, Brian. So I think that the logical maybe next evolution, unless there's any other points to clarify, Lauren or Brian Pounds, on kind of the existing lawsuit and maybe some of the things that we were talking about as far as market confusion, to maybe focus a little bit on kind of this update to the suit and this amendment that was made, and maybe dive deeper into some of those details.
Sure. And so the amendment, so they filed the amended complaint yesterday, or maybe late on the 16th. So,
and this was due to the fact that Behringer changed the name and the logo on the pedal. And but before we get into that, can you tell us, would you have advised them not to do that if you were their counsel?
Yeah, there's a lot that I probably would advise them to do differently. I
want to hear those. I want to hear those.
I would probably tell them, take it off. And if you want to keep making this pedal, if there's something super special about this pedal, change the name. But I would absolutely be engaging with Klon over it. So typically in a lawsuit, settlement discussions are protected under the federal rules of evidence, which what that means is they can't go into a pleading. You can't be like, look, he offered to pay me $3 million. So it shows that he knows, he was wrong, give me my money, please. Settlement discussions, the back and forth, the negotiation, that is usually confidential. And so if I got this lawsuit and I was concerned about my client infringing and being on the hook for a lot of damages, to the point where changing the name and the look was my solution, I would say call the Klon lawyer and say, okay, let's talk. Let's negotiate this. Okay. Can you agree that my answer isn't due, can I, for another 60 days or something like that? I don't have to formally answer the lawsuit. We can save litigation and we can engage in settlement negotiations. Here's my initial offer. We're going to take it down. We're going to change it to this and we're going to change the color. Is that good enough? And then Klon's going to come back and say, no, you need to give me, some sort of monetary consideration for the pedals you already sold. How about $17 million, right? And then Behringer comes back and says, how about, $10,000? And then you kind of get to the point where the magnets are close enough together that they snap, right?
Mm-hmm.
And you have a settlement, right? Send out a birth announcement, everything's over, you dismiss the lawsuit, everyone goes home happy. That's usually how it works. Airing the dirty laundry and getting all aggressive and hostile, it just drives up the litigation costs.
You have the best phrases, Laura.
Yeah, these analogies are actually very helpful. We can there's a palpable feeling of what it's like to to be there. So can you give some examples that where you felt like that was evidentiary in sort of the settlement, like in terms of sort of escalating things?
Mm-hmm.
I'm presuming it's on the side of the Centaur folks, the Klon Centaur.
Yeah, I mean, it's hard to know if settlement negotiations have taken place because I don't know if a demand was initially sent out. I don't know if the first time Behringer learned that Bill Finnegan was mad about this was when they got served with this lawsuit. Probably not. I imagine that they probably knew that this was going to tick him off or that had ticked him off. And so if they're going to go change, and it sounds like they changed it without saying anything, which is also kind of strange because once you've filed a federal lawsuit and you have created these downstream ripples where podcasts are being made about it, TikToks, Reddit subthreads, people are paying attention. You don't just get to go secret away, change things and hope that that's going to resolve it, because someone is going to notice. And I think Klon they've got some reputation now at stake for filing this, right? Because I think a lot of people were like, dude, like what are you doing? Like, why are you mad? You don't care about these other ones. There's some issues here we don't understand. So he's got some reputational stake in the game outside of just, allowing clones of his products to be made. So he's going to notice if you change the name of the product. And then he's also going to notice that you changed the name of the product by removing one letter and adding another. I mean, I'm not sure what their strategy is, but maybe that is their strategy, is like keep us guessing, right? And they confuse us so much that nobody knows what's going on, or they want to get some free legal advice by listening to this podcast. I don't know, but I'm not sure. And kind of, what I thought was going to happen when I saw that they changed everything, is that it was going to be seen as evidence of willfulness infringement on behalf of Behringer. And that's an important term in the legal field because it enhances the damages. And back to that damages and now, calculation with the actual versus the punitive or the statutory damages. If you can establish willful infringement, the I did it infringement, then you're kind of eligible for these enhanced damages. There's also a provision in the law. It's called a counterfeiting statute. And so to take many, many steps back, the Lanham Act is the enabling congressional statute, the act that provides for these types of lawsuits. So it's a federal code. It says, hey, if you infringe on a trademark, but it also has counterfeiting and it has false association and false advertising. All of that kind of goes under the Lanham Act's purview. And if there's willfulness on the part of the infringer on any of those prongs, you're eligible for those enhanced or treble damages. So what Klon did in the amended complaint was they added a whole new section. Okay. And I will share my screen.
Yeah,
to
sure. Go ahead and share it.
Pull up these paragraphs. Well, they added a lot of new sections. The other big section they added was on actual consumer confusion. So we had mentioned earlier that there's digits of confusion. There's these factors that a court is going to analyze how confusingly similar they are. Market strength is one, but another one is actual confusion if someone has actually been confused. So Klon put in a lot
of individuals that were confused.
Yeah, lots and lots of screenshots.
It's like those the one or two dentists that didn't choose Sensodyne.
Right. Or just like the Pepsi challenge, right? Like they're like, I think I'm drinking Coke. Like no,
gotcha.
I also love it that guitar message boards for how contentious those can get. The fact that they've now ended up in a complaint in a federal lawsuit. I think everybody's going to really be happy about that on, whatever board you look at. Just now everybody's going to be making legal complaints.
Yeah, I'm curious, so it's John Smith on the gear page is being subpoenaed to testify in the...
Okay, so I'm sharing my screen. This is the amended complaint.
Okay.
And like I said earlier, it replaces the original complaint for all intents and purposes. So it keeps the original infringement claim against the Centaur overdrive that Behringer was making, and then it adds the post litigation actions of Behringer. So it talks about this new infringing Centaur pedal and why it is infringing as well. It's got lots of pictures. They say it revised the web page to remove the counterfeit Centaur to now an infringing Centaura. And these are legal terms, but basically what they're saying is they took the copy that they made, the exact replica, which is a counterfeit, and they replaced it with something that's just kind of a knockoff, clone type thing. And so it's infringing. And their argument is the Centaura is not really that different than Centaur for purposes of trademark protection. So this was the Venn diagram that we were talking about, where how similar is the mark? Well, how similar is Centaura to Centaur? Pretty, one might even argue like Centaura might be, and I don't know, it's like this, Spanish word for Centaur maybe, or the Latin word for Centaur. I don't know. I'm probably showing some serious ignorance. Please feel free. It's not that different. Like we had talked about it. They had gone with Tumnus or Minotaur or just something.
Well, I'm wondering if they're thinking of like there's the Centura, right, which is the Ceriatone one, which is also sort of just a few letter substitutions. And then Brian, what's the Worm Audio one called? I forget the name of the what they called it, but it's some sort of derivative that sort of has shared a shared syllable, maybe,
with all the evidence of the confusion that is. Yeah, it's something very similar. I can't remember. Brian, right? Pounds.
What, the Centavo?
Centavo? Yeah. So there's a lot that are kind of there, but I think I saw their market confusion. Is this?
Oh yeah, this is where they're saying, I'm trying to scroll like YouTube comments, like, how is this called Centaur? What is happening? Like, what's going on? So this is all new stuff that they're adding, where people are confused about why it's called the Centaur. And so those are really the two big additions to the amended complaint. All the other stuff is still there, although he did increase his. Bill Finnegan said that he upped it. He said he had 30 years of experience in the field in the original, and upped it to 35 in the amended, which is amazing that he got himself 5 extra years of experience in the field.
If he rounds
rounded up, right? Yeah. So between May and July,
that was the threshold, right?
4.5. Yeah. So he got himself some more years in the
Yeah.
last couple months.
It does ring better, I'll say that.
Yeah. And that's a lot of experience. I mean, 30 is a lot too. So that's talking about those digits of confusion. There's a lot of factors. But the four most important ones are the similarity of the marks. That's the 1-to-1, centaur to centaur, relatedness of the goods and services, right? Guitar pedals to guitar pedals, evidence of actual consumer confusion. Is someone saying, what, who is this? What? I don't understand.
Is
I
it
had,
licensed?
is it licensed? Right. And then marketing channels, which is what we were talking about. Sophistication of the consumers. There are different types of purchasers. Someone purchasing a house or a car, or maybe even a guitar pedal, given the price tag of some of these, is going to be much more discerning
Right.
when they're making their purchase. They're going to be able to look at similar sized, shaped, colored products and tell the differences between the two because they're so expensive. You don't just buy a guitar pedal. It might be a different than like an impulse buy at CVS, right? So if you've got M&Ms and N&Ns, it may not be as big of a sophistication of the consumer's argument. So that's part of it. The differences in the cost certainly would be enough to alert people, but none of those factors by themselves is dispositive. And when you look at the balance of them, you've got similarity of the name, similarity of the goods and services. You've got defendant's intent is also another one, which seems like they're just admitting that they intended to copy and, or maybe trying to walk that back. I don't know. And then actual consumer confusion, which to me, from a negotiating standpoint, is one of the strongest tools I have to try to reach a resolution. Because if people are genuinely confused, that means they're confused both ways, which is to say that you are losing sales too. So if you copy someone and you make a clone of their product and people are coming to you thinking you're them, right? And you're taking sales from the person you're copying, they may also be going to the other person and taking sales, from you. And so if there's actual genuine confusion, you really do want to resolve that. Mm-hmm. This is a more of a personal story, but my husband's name is James. His mother's name is Jamie, and his grandfather's name is James. And all three of those people show up on my credit report, and we can't tell the difference between whose Shell gas card it is, right? And I'm like, if his mom misses a freaking payment on her gas card, is my credit score going to go down? There's confusion here, and the credit unions seem unwilling or unable to fix it. You want to resolve that because if the person that you're being confused with messes up or makes a crappy product or gets caught on a Coldplay screen doing something wrong at a concert, right? And suffers reputational damage and people are thinking it's you, that's a problem. So evidence of actual confusion can be very persuasive in getting people to find an amicable resolution.
I think you should go to the credit union and say, well, have you heard of the Klon Centaur?
Yeah, that's right. I should.
Because boy, do I have a story for you about market confusion.
My husband wanted to name our son James as well. And I was like, no, I've not, he can't inherit this credit report fiasco. I'm drawing the line in the sand.
Yep. So name him Centaur or Klon.
Yeah, Centaur. Centaur and Minotaur at home.
Finally, he'll get the respect he deserves. It's when he's in school. Or he'll just be really tough.
If he does that, though, Lauren, you could correct me, but if you name him Centaur and then he starts making clones, couldn't he use a Centaur pedal because it's a name?
Yeah, that there are some. Yes, essentially, if it's your name. So I have a friend named Kelly Williams, and there's a very popular real estate brokerage called Keller Williams. And they sent him, and so he's got a plumbing company called Kelly Williams Plumbing. And it's like a KW. It does look very similar to Keller Williams's real estate brokerage. And they sent him a cease and desist, and he was able to throw up the middle finger and say, that's my name. So you can't stop someone from using their name.
So maybe Uli Behringer needs to change himself.
He does. Yeah, maybe if he names his son Centaur Overdrive Pedal. And then and he wants to sell pedals, he's gonna yeah, maybe.
He's gonna be like a 5-year-old entrepreneur.
That's right.
Gosh, have my son Centaur?
Yeah. That's
So
a cool name for
yeah. Well, I think that the thing that I want to kind of maybe wrap on kind of for sort of our last segment of the podcast is predictions. Where do you think that this is likely going to end up if you were to guess? And another question I have is, right now, obviously nobody has won or lost the suit yet, but I have to presume that Klon has spent, assuming that the attorney is not a family friend or somebody like that, that's giving them either a pro bono legal work, or like, I have to imagine they've already spent tens of thousands of dollars on this.
And they're going to have, and they're likely going to have to. It's possible that the Klon attorney is doing this on contingency fee, which we've all seen the ad, like we don't get paid unless we win, like Aaron Brockovich levels.
Right.
It's possible. Plaintiffs' lawyers typically, and Brian is one, so he can back me up on this. Work on contingency fees. Now, not usually in infringement, trademark patent infringement cases, because attorney's fees are not necessarily a guaranteed award, but it's possible. That said, I think the latest data on taking a trademark infringement case all the way to trial, and it has to be federal trial because that's the Lanham Act is a federal statute. So anything in federal court is way more expensive and formal and time consuming, but it's I think the average cost is like $1.3 million. Because so these things require expert testimony. They're gonna have to hire a damages expert, probably multiple damages experts. Someone's going to have to come in and testify about the strength of the mark. And there's going to have to be an accountant who's like, here's how much profit loss we had. And there's going to have to be, someone who's done a bunch of surveys to show confusion. And it's going to be on the other side too. If all of this goes all the way, it's very, very expensive. So you're absolutely right. But I don't know. I get the impression that Bill Finnegan, it's like, Darkwing Duck or whatever, or who's the guy who has the
Scrooge McDuck.
Scrooge McDuck.
Yeah. That he's got a safe that he swims in.
Yeah, he's diving into his pool.
I really hope he's also Darkwing Duck. That would
also be.
He's also fighting crime after building pedals.
He's probably just gonna pay him in I did the math. It's like 174 Klons if he sold them at like $7,000 a piece. I'm just saying, he's like in writing, I'll give you 174 of these if we win.
So but Behringer also seems like they're well funded.
They're $1 billion corporation.
Yeah. So they probably have the money. So what he's asking for is, I'm looking at the so the end of the lawsuit. Here, I'll share my screen again so you can see. The end of the lawsuit, the part that nobody ever looks at is
until today.
It's where it's called the prayer, and the request for relief. I guess it's another way to say it, but you have to list.
I see the Lanham Act invoked right there.
Yeah, the Lanham Act. So he wants the court to find that they've engaged in counterfeiting and trademark infringement, trade dress infringement, false designation of origin, unfair competition, all of those things. And then he wants, I think, at least $2 million. I'm trying to see if I can.
Yeah, it's on.
Oh, there it is. Yeah, 2 million.
Yeah, 200. They're $2 million per counterfeit mark, and there's 2 marks that he's alleging.
So 4 million.
So at least 4 million. And then he's saying he wants his damage to be trebled because it's willful infringement. So 12 million. Any other punitive damages, attorney's fees, interest. So if you get these awards, you can go back and be like, well, I was entitled to have that money when this lawsuit started. So you've got to pay me 7.5% on top of the award or whatever there's a, it's set by like a statute, like what the interest is. But that's
Lauren, are punitive damages capped in a trademark suit?
I don't think so. I think a jury could be like, you win $1 billion plus.
So that's an interesting point because I work a lot in employment law where there's limits to the amount of punitive damages, and they're called compensatory damages in that lawsuit. It's like emotional damages, things like that. But punitive damages are a part of that analysis. Typically, when you're looking at punitive damages, though, if there's no cap, one of the questions that they're asking is, what's an amount that would discourage the company from doing things like this again? Right? So when you're talking about in the amended complaint, they say that they have a history of taking these marks and making these pedals that are inferior but just look exactly like the ones that they're trying to copy. If there's a documented history of that, and the jury or the judge is going to consider, what's an amount that's going to be needed to punish $1 billion company to make sure that they're not going to continue to make Klon pedals or continue to make, what they're calling counterfeit pedals of this. That could be a significant amount of money, assuming it's not capped. I don't think it is. And that happens. It happens a lot in tort cases too, where you've got like wrongful death or someone, a work site is unsafe. And if the owner of the job site is a, $1 billion corporation, you can actually get discovery on kind of the net worth of these corporations. And so the jury can hear if it's willful or gross negligence or willful infringement, the jury can hear evidence of how rich these people are that did this bad thing and adjust their damages number accordingly. So it's interesting. In terms of the capping of the damages, I don't know if you remember the Alex Jones Sandy Hook defamation lawsuit that took place here in Travis County. So those,
because he's an
Texas,
Austin guy, right?
Yeah, he's going to sue me for defamation, but that's okay. The damages are capped, as we're about to find out. So, in Texas, there was tort reform led by our great governor, who a tree fell on him and it paralyzed him from the waist down. So he's in a wheelchair, and he got a lot of money out of that, and which enabled him to run for office and be a politician. And then immediately, once upon getting in office, passed tort reform, so nobody else can ever make that kind of money off of an accident like his ever again. So that kind of limit on damages, it also applied to the Alex Jones case, but the jury doesn't get to know about that. So they were like, "Yep, dude, you defamed and like caused terrible horror for these families of this terrible tragedy, and we're going to fine you essentially $1 billion." Well, what they don't know is that they could have written any number in there, 11 billion magical unicorns. But in Texas, damages are capped for those types of causes of action at like, I don't know, was it like 40 million or something like that? Like he was never going to be punished in the amount that they were finding. Not so in trademark infringement. As far as I know, I got to be honest, I've never had a case go all the way to the punitive damages troubling stage, so I don't know for sure. But
happen
I
all
don't
that
think
often.
so. Yeah. It doesn't seem to make policy sense for damages to be capped for infringement. If you're going to allow for punitives and trebling for willfulness, if someone's really being a bad actor, then they're don't do the crime if you can't do the time, kind of thing.
Right. Well, what do you think is maybe we'll have you each weigh in, Lauren and Brian. What do you think is the likely outcome for this in if you were to predict, and maybe what the timeline for that outcome might be?
I think the likely outcome is settlement, just because I think it's closer to like 99% of all lawsuits settle. Because it does get expensive. And while you might have a lot of fire brimstone at the beginning and you're like, let's go. 2.5 years down the road and 500 grand in legal fees later, you might be feeling a little bit of what we call litigation fatigue. So he might be more motivated to settle, or Behringer might, have the exact same thing and be like, this is not worth it over, a $70 pedal that we can just call something else. Let's settle and be done with it. Sometimes you get entrenched and that's and then who knows, all bets are off. But my bet is that they're going to settle this, and we probably won't get to know many details of it because there'll be confidential settlement negotiations. If they don't, it's going to depend on the judge who's assigned to this particular case, how quickly they move their docket. I know nothing, less than nothing, about the federal judges in Massachusetts. So I'm just going to say that right now. But it just depends. Some federal judges take forever to move things along, rule, either because they're busy, they got other stuff. The same rules still apply. Criminal cases get to take precedence because, people have constitutional rights and blah, blah, blah. But, so the civil cases kind of get kicked to the back, but it's going to depend on this judge and how quickly he or she moves their cases through. But if they've got a judge who's interested in efficient resolution, it could be done in a couple of months. I think I had a case that was filed, a federal case that was filed in March that was set for trial. It's set for trial the next September. So a year and a half, which is about normal, I think.
Would there be any value for Behringer to continue to sort of drag their feet and then like kind of use their sort of monetary advantage to try to kind of bleed out?
Yeah. The death by 1,000 cuts defense is what I call it. Yes. Yeah, maybe he'll lose interest, he'll lose steam. And if they've got a judge who doesn't rule on stuff, then they may answer this lawsuit and they may file a motion to dismiss. If they file a motion to dismiss, nothing else is going to happen until the judge rules on it. And I've got a case with a motion to dismiss sitting there that, it's been going on 6, 7, 8 months now, and the judge still hasn't ruled on it. And at this point, I'm like, just give me an answer, man. Like, I got to get on with my life. But, some people rule on things too quick. You just don't know. Federal judges, the difference between a federal judge and God is that God doesn't think he's a federal judge. They have a lot of discretion and a lifetime appointment. No one can tell them to do anything. If they don't want to do it, they don't have to. So anyway.
Well, I practice almost exclusively in front of federal judges, so I think they're all great. In case any of them are watching this podcast, I think you're all doing a bang up job, and I can't wait to see all of you when I'm in front of you in court. As far as likelihood of outcome, there's so many inputs that we don't know. That at the beginning of a lawsuit, like when I'm talking to my clients, really, if anybody is giving you predictions at the beginning of a lawsuit, it's like
just Hail Marys,
a significant amount of bullshit. You can bolster, you can say, but like ultimately where this all ends up, you never know what a federal judge is going to do. You never know what a jury, like 12 people in a jury box, are going to say. You don't. You can act like but you don't. People do crazy stuff all of the time. You never know who's going to be on your jury. Never know what a judge might have. The judge might, be a guitar player and wanted a Klon his whole life and never could have got one and thinks this is a great idea that they're $79 now. So there's too much unpredictability. That having been said, of the things you can predict, the 4 factors that Lauren mentioned, like the strength of the mark and the similarity of the marks, the fact that they were using the exact mark is a real hard fact to overcome. where some of these arguments typically come in is where you would have something like Centaur versus Centauro, right? Or Centaur versus Centipede, right? In the first one, you can say you make really odd arguments, really fun, creative arguments in trademark law. Like when you're trying to say likelihood of confusion, you'd be like, well, like Lauren was saying, Centauro may be the Spanish version, and people are likely to see this, and you focus on you literally like dissect the word and go, people really focus on the beginning of the word, and what it means is, anyways, you can get really into that. The fact that they were using the exact same word, that they were using basically the exact same Centaur mark, and I think it was even the same font. I really appreciated the fact that the Klon Centaur uses Times New Roman font.
Oh, yeah.
Which, for all of the creativity that you could have, it's just like default Microsoft. That's what I'm going for.
Is that mentioned in the suit as far as
yeah. If anybody wants to know, it is Times
but
New Roman.
But the Klon font is Times. It's all caps.
All caps, I think semi-bold or some
weird. The interesting thing is that doesn't matter. They have a word mark. And so the word mark covers the use of the name in they could be pink with sprinkles on it, right?
They could have used the logo though, because I almost feel like the change should have been they just leave the logo on there, the color, and like that is sufficient enough. It could be called the nameless pedal. And like
the pedal that has no name, the pedal that shall not be named.
I think they still have like state law claims in Massachusetts, right? Because that's where the trade dress and common law stuff comes in.
They would have common law trademark rights. So the logo is not protected federally. So it wouldn't fall under the Lanham Act, which was where all the crazy damages calculations comes in. But he does have a state law claim, like I'm using this in Massachusetts or wherever he is, and you're on notice. And so whatever infringement he can get, it's just not going to be as enticing. It's not going to be as big of an enforcement mechanism, but he would have common law claims that you get just by virtue of using the name.
And it would be relevant to like the fact that they look very similar, right? That would be relevant to relatedness of the goods or likelihood of confusion, right, Lauren? Because if you're looking at something that has all, like, say you took a Klon that has the exact same internal circuit board and everything, or whatever, and then moved it over to just a completely different enclosure, that's not gonna, I mean, you're still infringing upon, not infringing, but you're borrowing the what makes the pedal special, but you're not using the word right. But if you have something that looks completely similar, once you establish that the word itself is similar, they're going to look to what the pedal looks like, right?
It all goes into it, right? They're all factors, but the biggest two are the name and the goods and services. So that's where you want your Venn diagram. You want it to be two separate circles. You don't want the name or the goods and services to overlap or be similar to anyone else's mark. If you do that, then you won't get a nasty letter or lawsuit filed against you.
Yeah, it's an interesting conundrum for them, because I feel like they're, as I mentioned earlier, I can think of a recent device they did, which was a neutron envelope filter. And this was an envelope filter is a pedal that was really popular in the 70s in particular. And they kind of did a similar thing where they made the enclosure style very similar, but they shrunk it down in size to sort of make it more appropriate to kind of the way that people would use pedals now. And the colorway was the same. The bends, to scale were the same as the original. And they went forward and made it and sold it for, some lesser price. And they do that all the time, and so I wonder if this is kind of for them. The expectation is that they kind of just end up bulldozing companies all day long, that they never had any thought that like somebody would go against them. And then we're set with this David and Goliath stage here between the two of them. It's interesting to think that, how this might unfold. And it sounds like, according to what you've said, that we likely won't know the details of the settlement, just that it settled, unless it ends up going to court or something.
Yeah, if they settle, depending on at what point in the timeline they settle, they could be engaged in settlement negotiations right now. I doubt it since this amended complaint was filed like 24 hours ago, but they might be. The next thing you would see is like a stipulation of settlement and the dismissal of the lawsuit, and then that would be it. You might see a press release. You may see some sort of statement on a website. But usually those settlement agreements are confidential. Sometimes you can negotiate like, here's what you're allowed to say about it if asked. Here's what I'm allowed to say about it if asked. Like, and it's usually like, we have amicably agreed to resolve our differences and remain competitors in a marketplace with respect for the craft. I mean, something like that.
Right. Klon would probably want that just because they would want it as a discouraging, they'd want the to show the body, what happened to the
right. And and if you were in a strong enough bargaining position, you can say, hell no, I'm not putting a confidential settlement, which is why you see the billboards, certainly in Texas, I got $95 bajillion for my client. Those settlement agreements are not confidential, right? That's why he can put that on there. Right. And so then you get someone who, got rear-ended at 5 miles per hour in a parking lot saying, I want my $30 million. And you're like, no, that person lost like an arm. So it's not the same damages calculation. But we probably won't know. Now, what may happen is they go down this road. There'll be some filing, some motions. We can get more insight into what's going on, where people's heads are at. And then they may have to go to mediation. Most courts force the parties to try to mediate a dispute before trial, meaning they have to go sit down in a rented conference room with stale coffee and like Rice Krispies treats. And they go into, one party is going to go into a small room and the other
mediation, Lauren. I got some mediators for you to use. They got good snacks.
Well, the ones with the good snacks are like, $3,000 a day or something like that. Just give me
but
the
they do have
snacks.
Organic strawberries.
Yes.
Off season even.
And so they'll mediate.
Sorry, Lauren, go ahead.
I was just explaining mediate. So they sit in a conference room and they got a little guy he's called a mediator or girl, and she bounces back and forth and she's like, okay, how much do you want? What do you need? And then she goes over there and she's like, okay, this is what they want. Here's this problems with your case. And then she kind of tries to facilitate a resolution. Sometimes
and the court decides that, or do the attorneys?
It depends on the court. It depends on the district, the federal court, whether or not mediation is required. A lot of courts require it. Some courts even require you to pick a mediator, like as part of your initial kind of scheduling conference and disclosure obligations. But some courts don't require it. They're like, you want to fight and spend money? Have at it. But the number of times I've been on the eve of trial or, very close to trial and the court orders me to mediate, I've had that a lot. So, and it's usually successful. People don't settle until they have to, and there's no greater motivator than facing down a jury trial
and steal Rice Krispie treats.
And yes.
Yeah.
Talking about confidentiality of settlements, there's one kind of really unique thing about this particular lawsuit. I think I would have to know more about like guitar, pedal, and accessories and amps litigation that happens in this sphere. And it could be a separate podcast for you guys. If Bill Finnegan is really, really, really strong on just like the integrity of it and protecting the guitar market, and it's not a money thing kind of thing, and it's just he's really entrenched, there's a really interesting situation brewing with Dumble, because now that Dumble is not himself creating the amps anymore, and he's given the intellectual property over to I think it's his friends or whatever. There's gonna be there's already a lot of Dumble clones, but there's gonna be a rush to try and cash in on that mark, because they're gonna have to release some amps. They're gonna have to put it in use somehow, and then you're gonna want case law about what happens in the music industry. So like if you're writing that motion to dismiss that Lauren's talking about, what you do is you look back to old cases and you make comparisons, right? So if there's a case about RC Cola from the 80s, and you want to make a motion to dismiss now, if you got a case about cola or soft drinks or whatever, that's going to be really persuasive versus trying to make comparisons between cars, right? Right now, I don't know that there's a lot of precedent out there about like guitar pedals, guitar amps, and infringing. That, I mean, of course, there are for like the Martin infringing guitars from back in the 70s or whatever. But we talked a lot about when a product is in use. It's really interesting to figure out what might happen there, and having some case law precedent about just like the guitar industry and how those users look at products and how similarity of marks are evaluated is something that could benefit or hurt the legal landscape of a potential lawsuit that happens there.
Yeah. Well, I think right now, my understanding of what they're doing with the Dumble estate is they're taking a pretty broad brush to everything, and kind of at least having informal dialogue with companies and saying, we don't like the name of this. We don't like the name of that. We want you to change it. We want you to make it something different. Even if it's things that don't have a mark, or something that maybe is sort of is secondary, or sort of a modification, or something that was called something at one time, or something that there's one example of out in the marketplace that hasn't been made in 30 years. And I think it's more that they were so supremely screwed by this European amp maker and pedal maker that made something that was called Dumble Overdrive Special, or looked identical and was not at all. It was even more blatant than the Behringer one, in that it was the same size, the same dimensions, the same font, the same name, the same everything, and was represented as a Dumble amplifier for all intents and purposes to the consumer. Like, that to me was a pretty clear-cut thing. They had difficult enforcing it, though, because they hadn't made amps in however many 3 years or something like that. And so I think that their sort of reaction to it was like, okay, now we're going to go scorched earth on anything that's out there, because this is evidentiary of us protecting our mark, sort of thing.
Right.
I think at the same time, though, they're, I saw them create a replica amp for the trade show, the NAMM show. The first thing they're going to run into is they're going to get sued by Vox, because they have a checkered grill cloth, and that's the Vox mark. It's
trade dress, though. We don't know. That's what I've learned from Lauren today, is that it's not the Vox name; it's trade dress. So
yeah, so Vox is very, very aggressive about anybody that uses that diamond pattern on the grill cloth. And if that is their exemplar of this is what we make and this is the product, they're going to be, they're going to have to change that in short order, I would imagine. They'll definitely get a C&D, because their Vox is great about figuring those things out. But anyway, that may be a podcast for a future time. And I just wanted to again extend my appreciation to Brian Pounds for organizing this, for reaching out and offering to present some context, and then Lauren agreeing to come on and speak specifically about the details of the case. And, although she didn't show every single element here, there are 70 or more pages of documents that you had forwarded to us and that you had researched and gone into. And so I want to just appreciate you for the time and energy that you spent. And for those that are in need of some legal counsel along these lines, where might people find out about you, Lauren, and you, Brian? And we'll definitely have all your credentials listed here on screen and in the description and pinned comments. But if you could just reiterate verbally for those that are watching or listening.
Sure. So the law firm that I work for is called Cokinos, Cokinos. I have a.
Oh, yeah.
There you go. Yeah. So I'm on the website. My bio is up there. You're welcome to send me an email. It's laldredge@cokinoslaw.com. My phone inbox always open to chat about IP law. And I certainly, I do consults for free and, intro calls for free, see if we're a good fit. Being an attorney, it's a relationship. You sign an engagement letter with me. So I want to make sure you like me as much as I like you, and that we are a good fit. But you're always welcome to call, to chat, to talk shop. I'm always happy. I love this stuff. So,
And that would be restricted to Texas, or could that be anywhere where this was?
So I am licensed in the state of Texas, but I am also a licensed patent attorney with the USPTO, which means I'm able to file and prosecute patents in all 50 states. Trademarks, you actually don't need a state-specific bar. You need a bar number, but I can. If you live in Maine, I can file a trademark application for you. If you need to sue someone, you probably need to be in Texas, but I can help you find local counsel if you need somewhere in other states.
And Brian?
Well, I practice civil rights law, which is you don't get a lot of guitar work in civil rights law. But I do
But
like
bad
a lot
tone could be a civil rights violation in some
that's
states.
Right.
Yeah, that's true, right? But a lot of employment discrimination stuff, and then what's called Section 1983 cases, which are like George Floyd type cases. There's stuff that we do. So if you need that, or if you just want to talk about guitars, or if you need Lauren's phone number, you can reach out to me. I'm at a firm in Texas called Ellwanger Henderson. My email is bpounds@equalrights.law. And we do state court stuff, but civil rights is federal court, so we practice all over the 50 states. If you have, for some reason, a civil rights complaint that coincides with your guitar pedal interests, like I do, then sure, give me a call.
Brian used to work for me. He was my associate, and believe it or not, I'm actually mostly on the defense side of things. So I'm usually the counsel for Behringer. And even though I think I've come across pretty pro plaintiff, that's just based on the strength of their case. So Brian, got tired of defending the man, and wanted to go actually
in hell.
So he left and went and worked. Jay Ellwanger was my mentor. He went and worked for my mentor stole my mentee. I'm just like, it's very frustrating. But I'm very happy for you.
We got to get him on the podcast because I think he did IP stuff too. So that would be another good opportunity.
I'm sure that there's going to be follow-ups to this that we may call on you to come back. Yeah. I think it's been really enlightening and I have to say, I've spoken with, many attorneys over my time and being in business, and I appreciate how succinct and eloquent you were in being able to sort of synthesize this complicated information, both you, Brian, and Lauren, and helping make it palatable to our listeners. So I think I'm speaking for them when I say thank you for that, and that was incredibly enlightening. And who knows? Maybe you'll get a call from Behringer or Klon LLC here.
I'm probably conflicted out from representing Behringer at this point. All of them and their attorney's dumb, but
their box is pretty litigious. So make sure they got your phone number.
Yeah. All right. Well, have a wonderful rest of the day, and thank you again for being here. And until next time, we'll see you back here on the podcast next Monday for our listeners, and we'll look forward to hearing from you then.
All right. Bye, guys.